Is it recording? It is recording. All right. So when you get home and you're watching this video, I did not have court today, and so I was very relaxed in my attire. Okay? All right. Okay. Y'all ready to talk about family law?
Yes.
All right. So let's get started. Everybody ready? Got your PowerPoints? Everyone got a copy of the PowerPoint slide?
Got it.
Can I have one person just do a couple of lights for us? Dim the lights. This is family law. All right, you need a PowerPoint slide? Yes, sir.
Yeah.
All right. Does everyone else have a copy? All right. So what we're going to do is go over some general principles in family law. Because it's my favorite subject. Can I have that erased over? Thank you so much. And if you can kind of stay a little bit in those groups we constructed, only because as we go through, I might want to have you Google a site or a statue or something, so we can kind of make sure we have some, you're next to someone if you don't have your own thing that you can access the internet with, okay? All right. So before we talk about the marriage, we talk about the before the marriage discussions that we sometimes have. And so the first term you're introduced to is the idea of, interesting.
Email.
Is that you? Okay. Of prenuptial agreements, okay? And basically, all you need to understand, you've heard of this term before. Basically, it's a premarital contract that we're going to come up with that's going to talk about and set the terms and conditions for the division of property in the event that we should get a divorce. Any questions about that? All right, so that's the general idea. However, we cannot disinherit the other spouse if no provisions are made under a valid will. So basically what this is saying is that if you are my spouse, right, and we're coming up with this prenuptial agreement, I cannot, even if you would be willing to do so, I cannot construct a prenuptial agreement that would write you completely out of inheriting anything that you would be entitled to under the law if we had this.
Really?
Does that make sense?
Can you do $1 though? I've heard if you will.
But I can give you $1
Okay.
or $50, right? But I can't completely inherit. I can give you something, but I cannot completely write you out. Which I just think that's kind of lame. I mean, but when you see contracts like that, or when you see wills like this, when we talk about wills,
Bad attorney.
it's just sad too. It's like, come on, how sore is that to say you're gonna leave the person $50? But maybe
Well, maybe they're both millionaires. I think
Well, I think in that particular circumstance, we could understand that. Unfortunately, that's not where I tend to see.
Bill Gates is the client.
All right. So, what we say about the prenuptial is that it is a contract. And that means that because it's a contract, it has to have all of the elements of a valid contract. When we get to contracts, we'll talk about what all the elements are. But one of the ones that are specific to this discussion is the idea that it has to meet the requirements of the statute of frauds, which is a SOF, which means it has to be in writing. Corinne, did you know that?
Yeah, I just learned that.
Awesome. All right.
I'm taking contract law right now.
Very
It's
good.
kicking my butt.
That's okay. So let me see.
Okay.
So statute of frauds, we okay with that? Now there are other things that have to be reduced to writing by virtue of the statute of frauds, but just in the context of this discussion, I wanted you to know that that's why prenuptial agreements have to be in writing. Any questions about that? All right, let's keep going. And then of course, lovely, we have exceptions. So your prenup has to be in writing, and you want it to be in writing. But there are some exceptions. One exception is where one party can demonstrate that he has significantly altered his position and in a detrimental manner as a result of reliance on the other party's promise in an oral agreement. So, because, okay. So this is one of those things where I'm trying to keep us focused on family law, but of necessity, I have to talk to you a little bit about contract law, even though we're not at contracts just yet. So bear with me, okay? All right, so in order for us to have a valid contract, and I'm just going to abbreviate it as K. You guys abbreviated in SK, Corinne, in contract class? No? I have no idea why we do this, but my professor just wrote it as K, and so I've just always done that. Okay, so for a valid contract, we have to have offer, acceptance. These two things, we have them together combined to form this magical union that we call mutual assent.
Mutual, yes.
Mutual. No, you were
Put me on the
so.
spot.
No, it's okay. You got it.
Yes, mutual assent.
Mutual assent. Then we have to have what's referred to as consideration. What consideration means is we have to have either a benefit to the promisor, or we need one or the other, okay? Or a detriment to the promisee. So in other words, think about this as we need some sort of exchange between the parties. Exchange. You'll also hear this referred to sometimes as quid pro quo. You get something, I get something. We're not concerned about value though, okay? So if Mary here wanted my water, I'm claiming water, okay? And I said, sure, I'll give you this water for $10, right? We could do that. With me, she's of sound mind, there's no mental things here, I'm not taking advantage of her, this is what we negotiated. So we're not concerned about the value, it's just there's been some negotiated exchange. Okay with that? Benefit to the promisor, I'm the promisor, they get a benefit? Get $10, right? Or is there a detriment to her? We don't need both, remember, so there's no detriment to her, right? But we just need one or the other, okay? Now, on the other hand, if I came in here and said, oh guys, I hit the lottery and I will give all you guys $100, is that gonna be valid consideration? A benefit to who? Yeah, so you're the promisee, right? Because I'm promising you $100, right? So is there a benefit to me as a promisor? No, that's not enough, right? So you have to just think about it that way, okay? So there has to be a benefit to the promisor, and if this is not quite sticking just yet, it's okay. I'm just laying some foundation for this other stuff we have to talk about, all right?
So you could say.
So that's not enough for a contract?
What if you said, okay, I want to have from everybody and I'll give you $100? Yeah.
Well, now are we talking about, what kind of hug are we talking about? Because the other part, it needs to be a legal contract. All right, so we're talking about the elements of a valid contract. So we have to have offer, acceptance, and consideration, okay? So the other thing might be like, say, for example, I said, hey, you guys, if y'all pay me $50, I will teach this class tonight. What do you think? No, because it can't be for something that I'm already required to do. So there has to be a present exchange, okay? I give you something, you give me something. That's all you have to think about. There has to be an exchange, okay? All right, so offer, acceptance, consideration. What else? We need legal capacity. And so for legal capacity, what I'm going to say is no eyes. No infancy, meaning under the age of 18. No intoxication.
Yeah.
No incompetency.
Yeah, you need to be a sound mind and body, so to say.
Yes. But we need more than that. Because I can be, well, 17-year-olds aren't typically of sound mind and body, but they could be. So we're saying, so no infancy, meaning not under the age of 18. No intoxication, and no issues of incompetency. Okay? You with me? So that incompetence, mental illness, things like that. But I just think it's easier just to truncate and say eyes, no eyes. Is that okay?
Yeah.
All right. We need legal subject matter. Meaning the contract can't be void against public policy. Okay? I don't know about the paying for the hugs. Lingering? You're being very naughty tonight. All right. Let's stay focused now. So, these are all right. And then we need statute of fraud compliance. Okay?
Wait, what was that?
Statute of frauds compliance. If it is a,
Oh,
if it is a moles, we'll come back to that. And I'll tell you what these things mean when we talk about contracts. But the first one here, this M, where property is, we have some property as consideration in the context of marriage. So, Nicole.
I can't see the letters.
M-O-U-L-S. M-I-C-K-E-Y-M-O-U-S. So sorry, M-O-U-L-S. So Nicole, I love you. You love me. We're gonna get married. Beautiful thing, right? We don't have to have our marriage reduced to writing. Okay, fine. You gonna marry Nicole? Andrew, will you marry me? I'm gonna divorce my husband and leave my 6 kids. Will you marry me? Okay, fine. That's just like, oh, wait. Okay, but the point is that if it's just love, we're fine. But if I say, Andrew, I will only marry you if you buy me that house in Bellevue, then now we've made property, a consideration for marriage, in which case we have to reduce it to writing. You with me? Okay. So how we get to this idea of the exception here? So we have to meet all these requirements, right? And then, like we said, we have to meet statute of frauds compliance, meaning it has to be in writing if it relates to one of these things here. For example, the the prenuptial agreement, okay? But now what we're saying is, well, wait a minute though. What if a person can establish that there was some sort of statement made by the other party, who is basically the promisor, okay? And they made that statement, at the time they made it, it was reasonable for the promisee to believe the statement, and they did, and it was reasonable for a promisee to rely upon the statement, right? And they did, and that reliance was to promisee's detriment because they changed their position based upon that promise that was made. Make sense? Okay, so reliance was to promisee's detriment because he changed position based upon statement or the promise, okay? So for example, no, we didn't reduce our prenuptial agreement to writing, but I didn't do so in the context when I didn't do so. Like, I gave up my job, because he told me I don't have to worry about working. We were never going to have any issues, when it came to him taking care of me. I always trusted him. He said, all you have to do, you follow me? So I have to show some facts and show some information that says, yes, we didn't have it in writing, but he made statements to me that were reasonable, and and he knew I was relying upon them, and in fact I did, and my position, my status changed because I was relying upon those things. So then we say, well, wait a minute, is it really fair to not impose this promise and make this person, honor the terms? Now, whether or not that works in a given case is just going to depend upon the facts, but that's just one of your exceptions. We okay with that? I know that was a long-winded way of getting there, but I just gotta lay some foundation for you. You guys okay? It's a lot, and I get that. So if you don't understand all this, like I said, don't worry. It's just some foundational stuff. We'll come back to this in contracts. Okay. No, we're good?
Oh, yeah.
Okay. All right. Okay. So establishing a valid contract. We talked about consideration, free will. Marry me now, I'm gonna get now. So free will, okay? No duress, no coercion, all right? Conditional divorce, not conscionable. So these are all the things that we're going to look for to make sure that we don't have anything sort of that's impacting this, okay? All right. So Andrew, I'm not gonna force you to marry me because that would not be legal. All right. So in the same way, yes ma'am?
What's a conditional divorce?
Well, a conditional divorce, what do you think that means?
We'll get divorced if this happens.
That's right. I mean, that's right. So what we're saying Now, these are all the things that sort of raise a question about whether or not there's free will. If you're going to condition my activities or things like that under the threat of a divorce, then we're going to say that raises a question about whether or not anything I agreed to was really made freely and voluntarily. We okay with that idea?
Yeah.
Okay. All right. So challenging the agreement. Lack of mutualist. So because the prenuptial agreement is treated like a contract, then we can challenge it on the same basis that we would challenge any other contract. So those other things that we just talked about, duress, lack of consideration, and so forth, those will be valid challenges we could bring to a prenuptial agreement. Lack of mutual assent, one party didn't fully disclose. So in the particular context of a prenuptial agreement, maybe one party didn't fully disclose of all of their assets that they had. And so then that would kind of beg the question, well, wait a minute, we could not have had, the other thing that mutual assent is referred to is as meeting of the minds. So I would say, well, wait a minute, we couldn't have had a meeting of the minds of me saying I didn't want any of your stuff in the prenuptial agreement. I didn't know you had 3 houses in Hawaii. I maybe might have said, I'm just saying, right? So that's going to raise a question about whether or not I would have agreed to that, okay? All right, let's see here. Don't worry about the second bullet point. There's a little bit more nuance, so don't worry about that. So we talked about the prenup, so we got past that. Nicole, will you be my husband? Thank you. Thank you. Andrew, whatever. So now, me and Nicole, we're going to get married, okay? So we have to make sure that our marriage meets certain requirements, okay? So like I said, I'm going to get rid of that other husband. It's a great insurance policy, by the way, so maybe we can't consider that. I'm just kidding. All right. So every state has certain requirements, okay? So this is one of those things where, again, we're going to make sure that we know what the requirements are for that particular jurisdiction, okay? Washington information, if you go online and you pull up the PowerPoint, there should be a link. Did I do that? Is it working? No? Okay, so I'll check and see if it's working. But it's just a nice little link there, but here's the information here. So capacity, consent, legal age, and competency. So again, that varies. What's our capacity in Washington State? How do we have to be to get married?
18.
Is it 18?
Mm-hmm.
What's the site? What's the site? What's the site? What's the site?
16 with parental consent.
Exactly. So we can be 18, or we have to have somebody's consent if it's going to be of a younger age.
Is it 16?
All right, King County marriage license. Here we go.
Consent.
So there you go. We have to have our marriage license, our 3-day waiting period. Do you guys know about the 3-day waiting period?
Mm-hmm.
Did you know your marriage license is valid for 60 days? So you got to get married within that time frame. Don't be like my husband. Oh, not you, my other husband. All right, blood test. Okay, so anyway, so that link works. Good, good, good. How does it pop back up? Okay, can't be in a close blood relationship. Can't be of same sex, increasingly no longer applicable. So that does not apply to Washington State anymore. Can't already have an existing marriage. Okay. And then blood test and waiting period for some states. And again, the extent of those blood tests and the time frame for the waiting period is simply going to vary by the state. Marriage vows. Where are we going to get married at? Church, right? We get married in church. We still have, so judge or minister, they're going to sign our certificate of marriage, and then we're going to file that with the recorder's office.
Doesn't the officiant file it, or
Yeah.
We
Yeah.
don't file it, they do.
Yeah, so whoever marries you,
Whoever married,
yeah.
file it, yeah.
So that all that's saying is that your stuff is going to be filed with the recorder's
Okay.
office. Yep. All right, our marriage relationship. Each has a duty obligation to provide for the needs of the household. Now, how that breaks down, what that looks like, the courts are not going to get into those nitty gritty, okay? So that's why it says court is not going to address those intimate issues, okay? Marital debt, welcome to marriage. All right? Most states have abolished doctrine of interspousal tort immunity, spousals, and so basically spousals can now what?
Sue each other.
We can sue each other.
wait, while they're married?
Well, typically, you're probably going to divorce each other.
Okay.
I
know you're
That's to the point where No. That would make for some interesting marital, No, but all this is saying is that. No, But hold on, it's a very, very valid question, because what it relates to and what this also has to do with is that it used to be that I could only not sue my husband, but I couldn't even testify against him for abuse or rape. So that's what those sort of things sort of relate to and tie to and help build a foundation for. Those archaic sort of principles we no longer have. And we recognize that a spouse within a context of a marriage is still an individual entitled to certain rights, to include suing their husband for tort damages.
And
Is it okay?
can you testify? Have you changed?
And absolutely, and testifying exactly against them. Yep. All right, third party actions. Now, so on the one hand, I just said we're progressive, but on the other hand, we said some things that we're still sort of tied to. So third party actions are the idea of sort of like, Ellie, do you mind being a mistress? You okay? So, all right. So, Naku, we were doing good. I guess we ran into some issues, and Miss Ellie, she was able to, whatever. And so, she's Miss Ellie. She's the other woman, okay? And so these raise sort of these are claims that I might file against her, this lady right here, for things that relate to her interference with my marriage. Okay, so criminal conversations, what is that? Criminal conversations?
Is it gonna be trying to take you out?
No, so basically criminal conversations and alienation of affections, they basically deal with the same thing. They deal with the idea of the wife or the spouse being able to file a claim against the mistress, or what do you call it when it's the guy? Is it still the mistress? A mister? I don't know.
Good time.
Basically, did you say it? Okay, but y'all understand the meaning, right? It's the idea that you can file a claim against the person with whom your spouse is having an affair. Okay? But like I said, these are uncommon and these are generally not very successful. It depends upon the state where you can actually,
How does that, is Washington's not an at-fault state?
That's right.
How
And
does that play into that?
it does not. That's what I'm saying. So these are uncommon, generally not raised, but it depends upon the jurisdiction. In some jurisdictions, where you have at-fault states, this would kind of come into play. We can introduce evidence of that. But when we talk about divorce in a few slides, we'll see that Washington, what do you file by? What do you say? What's the language? Irreconcilable differences, exactly. Because we don't like drama, right? It's like, okay, we don't need all that. Okay.
I would disagree.
However,
And this is not like relationship, but like in an at-fault state, if you don't have a reason that falls within one of those things, and you not get divorced, I mean,
you can still get a divorce.
but I mean,
You
it
can't
gets-
make.
Still falls under irreconcilable.
Yeah. So you're still entitled to get a divorce, though.
Gotta be a reason to get divorced.
Yeah.
Judge can tell you no.
Okay, so it really just is the specific
happens.
wording in the divorce that.
Yeah. So I think the answer is to your question is, even if it doesn't, you can always a party can always file for divorce and get in a divorce. It's just a matter of, in that particular jurisdiction, are there other grounds outside of irreconcilable differences that you can use or allege in your petition, and it's just going to vary by the jurisdiction. Okay. All right.
Can I ask a question, kind of?
Yes, ma'am.
Do you know, is Washington, I like how Washington has a 90-day cooling down period. Do most states do that for dissolution of your marriage?
That I don't know. To be honest, I really don't know. Yeah.
I think what they said in the book is like, because it's a no-fault state, there's a waiting period, but in other states that have reasons for adultery, there isn't a waiting period.
Yeah,
because of the reason for the.
Well, here's the thing. I can tell you right now, without having looked at any book on anything across the state, you're gonna have some period of waiting period. You're not gonna file your thing for divorce and be divorced the next day. So built in, there's gonna be some sort of period. The extent and degree of that waiting period, what that might be, I don't know. And if there's a mandatory required waiting period before they'll enter your decree of dissolution is just gonna vary. In Washington State, it's 90 days. In other states, I don't know. All right. Common law marriage. Marital relationships are created by agreement of the parties. Do we recognize common law marriages in Washington State?
No.
We generally do not.
Well,
Now,
I thought
your
you
next
shared bank accounts after
that's
7 years of
different.
being
That's
married.
different. That's still not common law marriage, yeah. So different things. So, and hold on one second, because I'm gonna tell you, if your next question is which states recognize common law, I wanna tell you right now, I don't know. So.
Move there.
All right, so it depends. So in Washington, what we do recognize is something that's referred to as meretricious relationships.
Okay.
And there's a whole sort of doctrine about what the elements are to establish that.
Can you see that? It's hard.
Meretricious relationships.
So debt must follow her meretricious relationship.
Meretricious relationships.
To prove that, I thought
Mary.
share a bank account.
So,
So,
I don't know where
So-
that got that though.
But here's, so what we'll do, actually, and maybe that's one of the things that we'll have you take a look at or whatever, so I'll have you quickly Google meretricious relationship in Washington State. It's, you have to meet certain elements. And the reason why I say it's difficult, it can be difficult to meet that, because that what you just said assumes that every person who lives in a meretricious relationship actually has a bank account. So if that's one of the criteria that you need to establish, hey, we were living in a house together, maybe we didn't have a bank account, or maybe we didn't have a shared bank account. So that's why it can be, so it always depends upon the facts and circumstances and what we can gather to support that, yes.
is that how you share debt under the meretricious relationship?
Is that what now?
How you share debt?
What do you
Because
mean?
then, like, if you're married and one person, one person has a credit card and it's only their name on it, it actually is, both people are responsible.
Well, it's not gonna be, so again, so there's a big question about whether or not that's gonna be shared debt, and whether I can establish that we had some sort of agreement that talked about how that debt was gonna sort of, be taken care of. And what might help in that situation, maybe where we can show like how, maybe there's, I paid sometimes, you paid other times, you know what I mean? If we can find those receipts, we can find, so it's always gonna depend upon what we have.
Go after both, even if one
Well, if
person's
you're-
name-
Oh, yeah.
Well, actually,
Because
well,
you're divorced,
just-
they
But that's different. Well, okay. So first of all, I want to stay on track. Second of all, that's a little bit different, because I can tell you right now. Over here, my name is Sarah Maine. Okay. Over here, this is Johnny Depp, because he's cute. Okay. We're not married. You with me? We are not married. Johnny Depp credit card was in Johnny Depp's name. I don't know what the legal basis would be for Johnny Depp credit card company to come after me right now.
You're not married, but if-
Exactly, that's the thing, because we're not married. If we're married, that's different, because now we're gonna talk about community property and community debt. So just a moment.
But we're not a community property state, so that's.
We
We are community
We
property.
are a
state.
community, okay.
Okay, all right.
Now
It's
get
okay.
it.
All right, so let's just back up. So, I know family law is so interesting, and we're gonna be tempted to go there to all the different nuances, but this is just a survey. So we're gonna do general principles and themes, okay? But take the family law class. We've got a great instructor who actually practices family law as well, and so you'll have a nice, what, y'all are just so, okay, too much sugar, let's keep going. All right, so we're talking about the idea of common law marriage. Not all states recognize. Generally, there's no public record made. Remember how we said when we file our marriage certificate, it's on at the recorder's office. Generally, we won't have that in this context. It's not based upon the length of time the parties live together, which is a common assumption, okay? It's based upon that and a whole bunch of other things. What we look at is, do the parties hold themselves out to the public as being married? Do the parties cohabitate? Do they file joint tax returns? They conduct their finances together? Did the conduct of the parties sort of evidence their intent that they were operating as a union, okay?
So what do we call that? If they did all that, what do we call that in Washington State?
So that would be your idea of the meretricious relationship. Okay? All right.
Is that different than domestic partners?
Yes, I think it is very different than domestic partnership. Okay? And we'll talk a little bit about that. Well, I'll have to think about how much time we get. I'll have to think about that, because we got 20 minutes. Are you guys, all right, so are we okay with this so far?
Yes.
Are you, I know.
Buyer's remorse.
Okay, sorry. That's bad. I should perhaps change it.
I like it.
All right, so an annulment basically is we want to undo our marriage, okay? So this is a judicial declaration that the marriage never actually existed. How you meet the requirements of annulment, again, it's going to vary by the state, okay? But basically what we're saying is that the legal requirements at the time that we entered into our marriage were not met. Say for example, the party was underage. That would be a basis for getting an annulment. Say for example, the party, he was already married, or she was already married. That would be a basis for an annulment, okay?
Then how
But
would the
the
marriage be legal then?
What now?
How would the marriage be legal if he was already married?
But that's exactly what we're saying. That's exactly why we're saying there's a basis for the annulment, because at the time, okay, I can't talk and you talk, so let's decide who wants to talk. But I'm interested in what you have to say, so you should talk.
Sorry.
Are you sure? Because I don't want to miss it. What were you gonna say?
Nothing, I forgot. Yep.
Okay, but I'm just saying, but we can't do it at the same time, though. That's all I'm asking, okay? If we were in court, the judge would tell me, Ms. Jarman, can I hear from so-and-so first? And I'm like, yes, Your Honor, my apologies. And I'm told that quite a lot, actually, I admit. So I understand, Patricia. All right, so, but what we're saying, so your question, Corinne, was, well, wait a minute, how could it have ever been a legal marriage in the first place? That's exactly what the point of the annulment is, because what it says is that the legal requirements at the time were not in place. Does that make sense?
Yeah.
All right. Okay, and let's see, lastly, we have this comment up here about you cannot have taken these steps towards accepting and acknowledging the marriage relationship.
the seal and the deal kind of thing?
Yes, that could be
Oh,
one example. That could be,
consummated it.
yes, that could be one
Yeah.
example, yes. But I like your language, it just took me a couple of seconds.
I couldn't think of another way to put it, sorry.
Oh, can you get annulment if one refuses to consummate?
Well, yeah, because at that point in time, we haven't sort of, I mean, if we've not done anything to take steps towards a marriage,
So then you could
then
get,
that might be a basis. I'm not familiar with any case law on it, but I'd be curious to see. But it seems like if you haven't taken any other steps,
yeah, then,
and then, again, it depends upon the statute. So in Washington, do we call it annulment? Does anyone know? No,
Well,
that's,
no.
so dissolution implies that we actually had a valid marriage and now we're
I think
getting,
it's called an annulment, isn't it?
so within your group, I want one group to Google, so when one group do, Google marriage versus relationships, Washington, and then the other group, I want you to Google, Washington and annulment. And let's see what you find.
Is the word divorce and dissolution synonymous?
Huh? Yes, ma'am. Yes, ma'am. I'm so sorry. I should have said that. Yes. All right.
What was the second one?
What are we Googling again?
No.
So you guys are Googling annulment, and over here we're Googling marriage versus relationships.
In Washington.
Yes, and make it specific to Washington.
A declaration.
Oops,
The declaration concerning the validity of marriage?
If you can prove
Declaration of marriage.
Sorry.
That one. Petition for declaration.
If you can prove that the family court that marriage is fraudulent and invalid, declaration concerning validity of marriage. Virtuous, a decree of invalid validity.
And that's Washington.
Court, not, you know, divorce doesn't work.
Decree of invalidity.
I mean, I could put
Decree of
That's just what it's
So
called.
rarely.
Yes.
Oh shoot! You guys, we have to hurry up. We have 10 minutes. What? I know, but time went by.
What are we supposed to be looking up about?
We're just looking up information about what marriage is supposed to be.
Or declaration concerning validity of marriage.
No,
Oh. Degree. Oh. Yeah. I just said degree.
Annulment proceedings are legally known as declarations concerning validity of marriage.
Yeah, I'm looking at the form on the courts right
Yeah.
now, the petition to fill out.
Oh come on! You guys, is it working?
It's quite a little bit.
Oh, look at, why can't I look at it? Oh, I have to put the word.
Good. There you go. Okay, there we go.
I should be open today.
All right. So what'd you find?
It's prostitute.
What?
What? It comes from the French word for prostitute.
Meretricious.
Okay, so,
Oh.
that's not what I was expecting you were gonna find. But that's definitely very interesting. Okay. So here's what you should know. Basically, the idea, while Washington State does not recognize common law marriage, the idea of common law marriage is basically you meet a time frame period and we say, okay, we're going to treat you like you're married. You meet the time period of 7 years, okay, we're going to treat you like you're married, okay? In some sense, that's probably easier than what you have to do to meet the meretricious relationship thing. Because there's that whole list of things that you have to go to establish. The duration of time that you represented yourself to be a married couple, that you intended as such, that you shared a household, and blah, 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 okay? And so the idea, though, is sort of recognizing that marriage is, while it may have been popular, historically, families are a little bit more global and a little bit more diverse in their construction nowadays. And there still should be some way that we can equitably divide, a household once those parties decide that they're no longer going to be together. And that's the idea of the meretricious relationship. All right, domestic violence. And marital violence. We kind of talked about this a little bit before. We talked about the idea that we can testify against the spouse. We can also, bring charges now that relate to DV and so forth. So we have a whole statute that talks about domestic violence and certain protections. The way that this has an interesting thing for Washington family law is that while we are a no-fault state, if you can show evidence of DV, that actually under the statute might entitle you to a greater proportion of certain benefits. Okay? When it comes to the division of property. So that's kind of a sort of interesting thing there.
With the statute of limitations in that.
All right.
Yeah, no kidding.
So end of the marriage. If you did it here, shame on your lawyer. Okay. Ending the marriage. So the court must have jurisdiction of the parties, right? So we have to establish some way that the parties were here and make sense for the court to exercise jurisdiction. Remember at the very beginning we talked about the concept of jurisdiction. The court has to have two types, personal and subject matter. All right, so same thing here. So residency, the marriage was formalized in the state. Major jurisdiction relates to authority of court over rights and duties concerning the children. And the reason why I say this, and I think your text has it in there too, is that for the most part, when we're getting the divorce, right, a party is not gonna really have any issue over the court exercising authority over them. These are just them, right? The issues that are gonna be raised are really gonna relate to, okay, but can you make me pay child support? Can you make me honor this visitation schedule and so forth? So it's really as relates to the children, because that's where the real fight in most dissolutions are. Property and custody of the kids, how much we have to pay. This next bullet point relates to the Uniform Reciprocal Enforcement of Support Act. Basically, you can think about this and the child custody as a way of having states talk to each other about different court orders. We have a lot of states, right? You can imagine that people move from state to state occasionally, and they move with their children after they've been divorced. So there's a whole bunch of drama and chaos in terms of parents trying to get that state to enforce, the order that was issued by that other state court. So these are just mechanisms in place to allow those courts to have that sort of communication and honor those court orders. Okay? All right.
So when you're getting a divorce in one state, do they do the laws in like, let's say, Alabama, and we married in Alabama?
No. So it's whatever state that you're getting the divorce in, that if that state has jurisdiction, that state laws are going to apply in terms of how that dissolution takes place. And yeah, that can suck.
Can you go back?
In which case, sometimes that might be something that people consider in terms of where they file for the Divorce Act. But again, you got to look at that particular state laws in terms of what's the requirement in terms of how long I resided there for the court to be able to exercise jurisdiction over me.
And each
Okay.
state's residency.
And each state might vary, exactly. Okay. All right, you guys. Let me see. I have 5 more minutes. You guys are packing up. The clock says 5 more minutes. I'm not packing
You
up.
got 3 minutes.
I got 3 minutes? Okay, well, let me do 3 minutes. Although on occasion, I've let you out really early, so, but okay, well, you're gonna hold me to 3 minutes. That's fine. All right, so grounds for ending marriage. We already talked about how Washington State is an irreconcilable differences state. However, in other states, we have these other sort of issues that can be raised, okay? Legal separations. So these are basically, you know, kind of tentative sort of divorce things. We can file these. We want to sort of have a formal parting of the parties, and this is also helpful where we want to make it very clear in terms of stopping the community property liabilities. Okay. Custody, care, custody, and education of the minor children, also referred to as the parental rights. So basically, the most important thing you have to understand here is the idea that we work with, what's it called when we work with kids? You hear it all the time, their best interests. Even in the event of death, presumption is that custody goes to the surviving parent, absent some showing that the parent is unable to care for their child. Critical, you have to look at the paternity laws for the state that you're in. If you are in a state like Washington and you are not married, then technically nobody has custody of your children. You do need to file a paternity action to get that established and have a valid court order. So for example, me and Niku, we're not divorced yet. We were not married. So, but we had a baby. Are you okay with that? Like, this is getting a little strange, Miss Jarman. And so, but anyway, so now we actually have to go to court, file a paternity action. Otherwise, if he could just come and say, hey, I'm gonna come get Niku Jr. and not bring him back, and I wouldn't have any real means to exercise any enforcement because there's no valid court order that acknowledges me as a parent and so forth, okay?
Even if you're the one that had the child?
Yep.
Really? I didn't know that.
Yep. Tender years doctrine, we've progressed, we've abandoned this. It used to be the presumption was that the mother had the, nurturing instincts and so forth, and she was the best person to care for the child. Now we see a shifting of roles. You have, stay-at-home dads and so forth. So now we've moved away from this presumption here. I apologize, Niku. I hope you're not embarrassed. We know that you would not want to claim me and my 6 children. Okay, so custody. Again, some things that we look at: the ability to care for the child. The parent's religion, very problematic. Your text notes that I put that's very problematic sometimes. Ability to attend to any special needs. Immoral conduct, again, that can be problematic because what's immoral? It used to be that you said that if the person was gay or lesbian, that was immoral. So sometimes that can be problematic. Ability to give continuity or stability, that's an important factor that the court will look at. Contact with the members of the child's extended family, and sometimes the child's desire, depending upon the age. Again, you're shaking your head.
I just went through a custody case and they wouldn't even take my 14-year-old into consideration.
Right, so here's the thing, depending upon the age and circumstances, every single family law case is gonna be very different. I've had some cases where they do actually look at and consider the 14-year-old's opinion, but again, depends upon the facts and circumstances. The other thing that we have here that might be helpful in terms of bringing the child's voice to the court is what? A guardian ad litem, special court assistance, and things like that. And then again, depending upon what type of proceeding it is, we're talking about this in the context of a family law, but if it was a dependency or something like that, again, the child would have his or her own attorney as well. Joint custody. The court really does, I'm sorry, this last bullet point is from your, from the text, and I forgot to put in here, very problematic, because it says something about that the courts are hesitant to give joint custody or joint whatever. That's actually not true. The courts want to encourage parents to be adults and co-parent, and so they really do look with an eye towards you guys coming up with joint determinations in a joint order. Let's see. Child support. Bottom line, you have a child under the age of 18, you're gonna pay. The question is gonna be how much you pay. So that's what that just notes. We'll take a look at, and I will post links to the child support worksheet so you can take a look at what kind of information you would put in those. And I think in your exercise, have you looked at the child support worksheets? Yes. No? It did? Okay, I thought it did. So if you didn't do the applying the concept exercise, go back and look at it. Even if you don't want to complete it, there's some good exercises on there that sort of show you what these forms and documents look like. I'm going to skip over that. Modification. So the last thing that I'm going to talk about real quick, if you'll give me like just if I can borrow 5 minutes of your time, is that okay? Sure. Thank you so much. If I can just do that, then we have custody, visitation, and we'll come back to the property thing. with respect to the modification, so essentially what happens is, so we file our petition, okay? Then we can have temporary orders to sort of, make sure that there's somebody who's still paying the mortgage while we're waiting our final, whatever. We have some final orders that also talk about the visitation schedule and so forth, okay? Then, we have our temporary order. Then we get our final order, all right? So our final, whether we go through a trial or whether we hopefully agree or we reach some sort of settlement, okay? We get a final decree of dissolution. We get our final parenting plan and our child support order, okay? We okay with that? Mm-hmm. All right. So then the question becomes, well, can I modify that? So there's some language in the statute that talks about there has to be what we call a substantial change in circumstances, okay? And that was in one of the cases, there was one of the cases that sort of spoke about that language. He wanted to sort of, you guys remember the Sanchez case, very good. All right, so when we want to make some sort of change, again, we have to petition the court. Let's see, in the context of child support, if there's an issue related to the failure of the obligating parent to pay, then they can be held, I should say contempt of court. Their license could potentially be suspended, and there's some other issues that potentially come up. You can see the problematic nature, though, of suspending the person's license. The whole idea with that, well, first of all, you want the person to pay, and oftentimes they pay because they have a job and they need a car to get to the job. So again, these are measures that the court will take, but in terms of when you take them, that's a question for debate. All right, visitation. The idea is reasonable visitation. The non-custodial parent is entitled to visitation. That's just, it's going to be a given. Absent you establishing that there's some sort of basis for the court to impose a limitation. What the basis of that is, it's just going to depend upon the facts and circumstances. Maybe you're alleging some DV issues. Maybe you're alleging some abuse allegations or something like that. Those would be things that the court would look at. And again, that would be the why we might have a case that was transferred to family court services or something like that, so we could get that GAL opinion or something.
Joint custody doesn't fit in there, right?
I'm sorry? Oh.
Joint custody means that you're both custodial.
That's right. So we're still going to have, and this is kind of where it gets a little bit confusing. So we're still going to have a person who is determined to be the primary custodial parent, just for purposes of who is, just for legal designation stuff, whatever. But that's separate and distinct from us having joint custody, where we still say, okay, but we're going to split. The child's going to be with me 50% of the time. The child's going to be with you 50% of the time. We'll make joint decisions about education and so forth. Okay.
But there's no visitation, there's just a parenting plan that describes how...
The parenting plan is going to describe all of that. And what I'm going to do, I go back and forth because this is not the family law class, but again, it's your introductory thing. I'm actually going to, so these are fine for right now, but what I'm going to do is I'm going to go back, because I don't want you to have to look for it. I'm going to make an announcement that says, here are some interesting leaks that relate to our family law discussion. And I'll put on there a petition for dissolution, a parenting plan, and so forth. Is that okay? Yeah. So I'll do that. And the child support worksheets. That way you don't have to look for it. Okay, let's see. Talk about the visitation thing. Property, marital debt, blah, 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 blah. Okay, so I think for our purposes, the one thing that I want to explain to you before I let you go is the idea of the property and debt division. And it's very simple. The only thing that we're gonna say is that the property that I had before I married, who said me? Who wants to marry me?
I was asking.
Well, dang, I think
she does maybe.
Well, I won't be proposing to you then. All right, so here's our timeline. Here's our marriage, okay? Everything over here, so this is my single life. Single life, okay? Mine, okay? Over here, marriage. This is me, this is my partner. We hold hands, we share, okay? We share the property, we share the debt, the liability, all that. With me? Over here is our separation, okay? Now we're back to mine, yours, all right? The presumption is that while you're married, whatever comes into the household by way of income is the marital income. Whatever you obtain by way of debt is the marital debt. All right? There are exceptions. If I can show that what I had before, if I can show that this was never, I cannot have commingled this. So you can see how this gets a little funny, right? So say I bring into the marriage $30,000, okay? We get married, this is mine over here. We get married, I have $30,000 before I get married. My husband has his house. You with me? Mm-hmm. We stay in his house. Man house, okay? I'm just trying to distinguish that this is his house, okay? So he's gonna say, well, wait a minute, I had this house before we got married. This is not community property, right? But let's say $30,000 of my money came to improving this house, right? Or some of our income that we got while we were married went to improving this house. Well, guess what? It's now been commingled. So now this is gonna be community property. Are we okay with that?
And so is your 30.
Huh?
And so is your 30.
And so it's, well, whatever I may have used towards here, but I can still have this. If I can trace this back, which is it's mostly going to be hard to do. So you're right. Reality is probably going to in. Okay. Okay. All right. Are we okay with that idea?
Yes.
All right. Let's see. Pension and other benefits. The presumption again is I'm entitled to half of that. This is the real hot mess of the divorce thing. The divorce didn't decree. That's all fine. We worked that out. But then we had to do this final ugly document. Do you know what that document is called? It's a dirty word. Just quadro for the division of the pension and all and retirement. But we're not going to even go there. That's like a family law question. All right. So basically, what you need to know is that presumption is that retirement while we're married, party gets half. Okay.
Well, half of the marital property, not half.
Half of whatever I have right here. What are you clarifying?
Half of the date of marriage to the date of separation.
That's what we're saying.
Not the whole. Like if he was at the shipyard.
Right.
Right.
So if he worked 10 years at this regarding his retirement, no, she's not entitled to all that.
Right.
Yeah.
Entitled.
Okay. But right here, while we were married for 20 years. I don't get the 10 before we were married. That would make sense. But I get 20.
Okay. Wow.
Right?
Right.
Okay. All right. Let's see here. The rest, I'll discuss on I'll make you a lovely video now that I have it working. Okay.
And then we're taking the quiz on this on Saturday.
Are you okay with that? If today is Monday, if I post, I'll open it up tonight.
Okay, good. Because I need to take it.
You have to what now?
I need to take it off Thursday.
Okay, so the quiz is open and it's due when? Yeah, so when you take it is not an issue.
When is this gonna be posted though?
I'm gonna open it tonight. So here's the thing.
Already open.
Huh? Or is it?
I don't know. I didn't check.
I just wanna be able to review the
No, I
video
haven't
before
seen it on there.
Yeah, so here's what I would ask you to do. Thank you so much. Here's what I would ask you to do. I'm gonna go home and upload. It takes I don't know why it takes so long, but it takes like an hour to upload it or whatever. You'll have 2 videos. You'll have this one, and then you'll have the rest of my discussion of the previous things. The other thing you'll have is an announcement with those links to the helpful documents that it might be sort of nice to be able to look at, all right? Then I'll go ahead and open up your quiz. So by tomorrow morning, at least by 7, you should be able to come and see those 3 items, all right? Actually those 4 items. The 2 videos, the announcement with those helpful links to the documents, and then your quiz, all right? Now, when you take your quiz, I don't care. Just make sure you do it by the due date. Okay? All right.